Arbitration practices are evolving to keep up with the needs of a fast-changing, globalized world. By constantly developing and embracing new strategies, DIAC strives to meet the demands of an agile global economy, offering a dispute resolution framework that is not only efficient, but also forward-thinking.
Administered proceedings at DIAC typically start the same way, with the claimant or claimants filing a request for arbitration with the centre and paying a registration fee. The request must include the names and contact details of the parties, a summary of the dispute, a summary of the relief sought, and a copy of the arbitration agreement. Once the centre is prima facie satisfied that it has jurisdiction, the request will be registered and the parties notified. The respondent will then have 30 days to submit a response, which may include objections to jurisdiction, counterclaims, and the nomination of an arbitrator. After directing funds on account of the arbitration costs, the centre will then proceed to constitute a tribunal to determine the parties' dispute. Depending on the parties' agreement, a sole arbitrator or a panel of 3 will be appointed by the DIAC Arbitration Court. Once the tribunal has been constituted, it will be encouraged to hold a preliminary meeting with the parties to set the timetable for the proceedings and decide on procedural matters, including confidentiality, the exchange of submissions, evidence, and documents. Parties will then typically exchange submissions, with the claimant going first with a statement of claim and the respondent going second with a statement of defence and possibly a counterclaim. In many cases, a hearing will be held for witness examination and legal arguments, but in some cases, the case may proceed on a documents-only basis. The tribunal will then deliberate and issue a final award.
Perhaps the most valuable form of support that DIAC provides to its parties is by maintaining a modern and fit-for-purpose set of arbitral rules and other rules for other forms of dispute resolution. Along with, of course, practices and procedures that allow for the dispute of the parties to be resolved in an efficient, expeditious, fair and enforceable manner. Also, by opting for arbitration under the DIAC rules, the parties benefit from the full institutional support of the centre. And what this means is not that we can provide advice to the parties, because as an independent and impartial arbitral institution, that is not something that we are in a position to do. What it does mean, however, is that we act as a point of contact for parties and tribunals, and we act as a guide for parties, guiding them through the various procedural steps in DIAC arbitration. In short, we provide a safe pair of hands for the parties to entrust their dispute to. And we have expanded our casework team to ensure that we have a diverse team who are very experienced in arbitration with a proven track record from either other international arbitral institutions or private practice, and qualified in both civil and common law jurisdictions.